A against R.
Good morning, Miss Wakefield.
Good morning. If I might start my reply by commenting that it is essential in my submission to maintain intellectually the difference between our various grounds of appeal and the sub-arguments, the sub-grounds that arise within those different grounds of appeal. I say that, of course, in respect of the distinction between jurisdiction and content of the law, as we discussed yesterday and the day before. But I also say that by reference to the no customary law point, the aspic point, compared to the Snell and Beadle point, and also to the difference between the Snell and Beadle point and whether, in fact, customary law has evolved already to contain the right posited. And, of course, between that last point, has it evolved already, and the Morton and Paint, can this court now evolve the law? So each of those is a separate argument. And I say that that's an important observation to begin my reply with, because many of the points made yesterday were presented as if they were blows which struck out the entirety of my customary law argument. And in fact, those blows, if they land anywhere at all, tend to land on the aspic point. So, for example, references to customary law of Sark, it's true that that's against my there's no customary law of Sark, everything was locked down in 1595 argument. But it says nothing about Snell and Beadle, nothing about the proper interpretation of l'approbation, nothing about the content of customary.
Can you just summarise what should it say about Snell and Beadle, or what does Snell and Beadle say about which there is anything to say?
Snell and Beadle, which must be common ground, says that anything which is in l'approbation cannot be abrogated from.
Yes, yeah, I see.
So that's what it says.
Yes,
Except by statute.
Of course, statute is
But
not by customary law.
Judge-made law does not extend to the repeal of the approbation.
Absolutely. So references in statutes to the existence of Sark customary law tells us nothing about the proper scope of Snell and Beadle and whether customary law, in particular, the posited customary law we're talking about today, exists or not. That's my opening observation. Then I'd like to turn to the maintenance orders, reciprocal enforcement, bailiwick of Guernsey law 1984. Now, that's the law that was referred to in the Chief Pleas minutes that I handed up yesterday.
Yes.
I hope you've got it to hand. First of all, I'd like to take you to the arrangement of the sections on pages 7 and 8. So on pages 7 and 8, we see section 25, application by married woman in convention country for recovery in Guernsey of maintenance from her husband. Section 26, application by married woman in convention country for recovery in Alderney of maintenance from her husband. 27, application by married woman in convention country for recovery in Sark of maintenance from her husband. Section 28, further provisions relating to recovery in Guernsey and Alderney of maintenance for children. No reference to Sark. If we turn to the sections themselves, and section 25 is on page 43, we'll see in the side notes, in the columns, those same headings are repeated. So section 25, Guernsey, an application by a woman to her husband. 26, the same for Alderney. 27, the same for Sark by reference to customary law, I'll come back to. And section 28, again, the same heading now by way of side note. Now, you should have on your desks, my ladies and my lords, a little clip of documents that looks like this.
Yes.
So these are the laws of Guernsey and Alderney to which cross-reference is made in sections 25 and 26. Section 25, the Guernsey provision, it applies where an application is being made under Article 1 of the law of 1930. That's the first law in the first tab of your small clip. And you'll see Article 1. It's a separation order so that a woman need no longer live with her husband. It has a list of grounds which have to be made out, some fairly unpleasant grounds, it has to be said, to modernise. Going back to section 25 of the 1984 Act, we see in section 2 that the only provisions which the court in Guernsey may include in such an application under Article 1 when it's made by a woman in a convention country is a provision which is mentioned in section C of that 1930 law. And section C, you see over the page, is a provision that the husband shall pay money to the applicant personally for the use of herself or such children. Or under 2B of section 25, we see a provision such as is mentioned in section 2 of the Maintenance and Affiliation Orders law. Now that's behind the second tab. And section 2.1 there, it's on page 4 behind your second tab. And it says, an order under Article 1 of the separation law made on the application of a married woman, which contains a provision committing the legal custody of any children of the marriage to the applicant, may, in addition to any other provision, include a provision that the husband shall pay 30 shillings for the maintenance of each such child until the age of 16. Turning then to section 26 of the 1984 law, we see a similar reference in Alderney by reference to the Separation, Maintenance and Affiliation Proceedings Law. That's the third tab of your small clip of documents. It's an application under section 2. And that's on page 9 of that third law. And again, we see similar conditions which have to apply before the married woman can apply no longer to be made to live with her husband. And then we see, going back to 26.2, under A, that one of the provisions that can be applied by the Alderney Court is that in section C of subsection 1 of section 3. That's at the bottom of page 10 in your clip. And again, that's a provision that the husband shall pay to the applicant personally a certain amount of money. And then also it's little e, which is just on the same page, page 11. And that's a similar provision, but for children who remain dependent, essentially. We then, skipping over 27 for the time being, I'm going to come back to it, of course, see section 28. Now, section 28 applies to applications in the appropriate bailiwick court in the island of Guernsey or the island of Alderney for an affiliation order under the law of 1927 or the law of 1964. Now, we've got the Guernsey law of 1927 in the authorities. It's at tab 6, page 840. And I might just quickly turn that up, if I may, though I am rather mindful of time. Page 840, and again using language that we may all find rather repugnant. At 840, it says, but halfway down, Article 2, the magistrate may adjudge the man to be the putative father of such bastard child, and he may also, if he sees fit, having regard to all the circumstances of the case, make an order on the putative father for the payment to the mother of the bastard child, or to any person who's been appointed to have the custody of such child, of a sum of money weekly not exceeding 10 shillings a week. So that's the Guernsey law. The law of 1964 is the Alderney law that you have behind the third tab in your little clip of documents. And the relevant provision there is...
Sorry, where we've gone behind this little clip, you say?
Yes, we're in the third tab.
Yes, I'm there.
And now we're on page 16.
Yes.
In section 12.
Thank you.
Powers of the court on hearing of an application in affiliation proceedings. And then in subsection 2, if the evidence of the mother is corroborated in some material particular by other evidence to the satisfaction of the court may adjudge the respondent to be the putative father of the child, and may also, if it thinks fit in all the circumstances of the case, proceed to make against him an order, hereafter in this law referred to as an affiliation order, for the payment by him of, and then it sets out various maintenance-style sums. So I'm sure that, and my ladies, my lords, will anticipate the submission I'm about to make. I'll say that Section 27 of the 1984 law is an analogue to the previous two sections, Section 25 and Section 26. We see that not least because in Section 27, 2A and B, we see references to husband and wife and so on. We also see it in the headings, we see it in the structure of the Act. And I will say that there is no analogue and no reference to any customary law by reference to Section 28. And Section 28, maintenance orders, affiliation orders, those are the relevant equivalents to what's being prayed in aid today and what's being suggested as customary law of Sark. And so I say, although I take the point on pepper and heart, of course, but I say that the Chief Pleas, the minutes of the Chief Pleas, were entirely accurate in Article 17. And if the board does have occasion to revisit that passage, you'll see it's right in my submission that under customary law, the Sark Court cannot make orders for maintenance, but we are asked if we will enforce those from other jurisdictions.
But are you making a distinction between customary law of Sark as applying to maintenance for married women, which Section 27, is this your point? Section 27 recognises, even though it wasn't in the approbation, but there is no customary law in respect of maintenance for children. Is that the point you're making?
The point I'm making is that whatever the import of Section 27, and the main consequence of Section 27, I think, is to the aspic argument. Of course, it also must be not contrary to l'approbation, that's true. But whatever the relevance of Section 27, it doesn't mean that there is a customary law right to maintenance between an unmarried couple where you would need an affiliation order or something like that, and then a maintenance order to be made. Because I say that it is deliberate, it must be conscious, that whereas it goes Guernsey, Alderney, Sark customary law for judicial separation and maintenance orders, it only goes Guernsey, Alderney, and doesn't say anything about Sark customary law when we're dealing with exactly the sort of application that this case is concerned with. So I've used up half of my 30 minutes already. I'll whiz through my remaining points, if I may. Conflicts. It was said yesterday that the conflicts of law point was not put to the Court of Appeal in oral argument. That's wrong. Page 673 of the second volume of the record.
Sorry, page number again.
673.
Thank you.
By H. Records the appellant saying, now what is also important in this ordinance is section 2 because it deals with the applicable law for matters relating to movables as being the law of domicile. So section 2 says, les meubles suivent la personne et les immeubles le territoire. That's the very rule we're discussing. So all actions relating to meubles between two people are resolved under the law of their domicile. So that's 673 by H. I also say, of course, that the Court of Appeal wrongly failed to consider this point, and everyone agrees that this was a muddle in the benevolent language of my Lord Wilson. And we say, of course, that for those reasons we shouldn't be shut out from raising it on appeal. It was raised below and was wrongly dismissed. One other point in respect of conflicts relates to what les meubles suivent la personne actually means. And I was asked by my Lady Hale, even assuming that it means the law of the creditor, of the obligation applies, is it the law of their domicile or their habitual residence? If I could take you to tab 62 of Authorities, volume 5. This is Dawes. Get the page reference in 1 second. The bottom of page 2348. There are two references here. The bottom of 2348, we see that he says, in essence, Guernsey private international law draws upon English common law principles of private international law without the benefit of the various pieces of legislation. Then on the next page, page 2349, at the bottom, we see, in the context of succession, it is established clearly that the law of the last domicile, and it's the word domicile, of the deceased will govern meubles. And the other reference, which we have already in the bundles as well, is in the next tab, 63, at page 2374, Dicey. And that's in paragraph 24003. About halfway down that paragraph, just after footnote 6, equally sweeping dicta can be found in earlier cases for the proposition that the validity of transfers of chattels is governed by the law of the owner's domicile, again the word domicile. But these dicta were expressly based on the misleading maxim, it's not very flattering, mobilia sequunta personam, which meant that chattels, wherever situated, were deemed to follow the law of the owner's domicile. So again, we see domicile. So those are the bases, we say, for the application of domicile rather than habitual residence. As to pleadings, I was told in my submissions that the family courts in England and Wales have no pleadings, and I was asked what impact, if any, that had on the inherent jurisdiction or customary law points. Now, I don't know how interested the court is in this point, but apparently the Sark court has no rules of court, save in respect of fees. Section 15 of the 2008 law is at page 942 of the bundle, that would be in the first volume, empowers the court to make rules, but those rules shall not come into force unless and until approved by the royal court, and no such rules have been made or suggested in any event. So I'm told that what happens instead is l'approbation applies, and that Terrian did say something about rules of court, and that people tend to refer to le marchand, I think if I'm saying, yes, I'm saying correctly, le marchand, and which was a commentary on l'approbation published in 1826, but written earlier, which is described in detail in Dawes on page 2338 in the bundle. And I'll just hand this up now, if I may.
What was the bundle reference, you said?
2338.
2338.
Now, I can also, of course, obtain the underlying terrien on this point, but this is le marchand, and it's simply remarque 1 on the second page, on page 83. Par les articles 1 et 13, les juges doivent juger sur les choses qui sont proposées et respondues par les parties devant eux et par les choses alléguées et prouvées là-dessus. And so I'm told that that's the general rule. I'm not sure how far that advances matters, but that deals with the pleading point as much as I can.
Sounds like a description of the judicial function.
Well, I know.
I know your time is tight, but may I ask one question? Was there any agreement or evidence led as to the domicile of the mother?
I'm told that, yes, there was evidence on that point, but the position may have changed subsequently due to relocation. Again, I don't want to trespass on facts that may well be contentious, but yes, in short.
But there's been no finding of fact as to that in the judgments below. Anyway,
I think
I can
there
check,
may
I
have
can
been,
check
but it
that
may well
later.
be under appeal. That's the problem, that so many of these
Yes.
early orders have gone up.
Yes. Thank you.
Turning to jurisdiction, the first point is the relief that we sought, restoring the order of the 4th of October 2013, which is at page 754 of volume 2 of the record. I entirely take the point that's made against me. That's inconsistent with our first ground. And I have instructions that we'd be happy to abandon that remedy. I can only apologise for that featuring in the notice. The Royal Court My learned friend referred yesterday to a seal being given by Edward I. I think this must be taken from page 2392 of Ogier, which is behind tab 67. We say simply that seal was given to the bailiwick of Guernsey before the island of Sark became uninhabited, before the new Sark court was established, and you've already heard my submissions, I'm sure more than you want to, on asking for a seal and not being given one, so I won't repeat them again. I'm not sure what consequences said by my learned friend to flow from the name royal, but obviously we don't agree that the Seneschal is a royal court. If it assists, on page 787, which is in the authorities bundle, first tab, we have that statement by Charles when he was, Charles, I say informally, King Charles, I'm not sure which one because my history is dreadful, in 1675.
Charles II.
Charles II, thank you. And that's at point 4856, page 787. And 3 lines up, or 4 lines up from the bottom, if anything, he indicates it's a manorial court. And he says, I do give oath to a seneschal, sorry, that's 6 lines up, and establish such other officers as shall be requisite for the administration of the civil justice there, and who shall be named by the said Sir Philip Carteret in like manner as the said Sir Philip doth at St. Owen in Jersey, and other lords of the islands of Jersey and Guernsey do appoint in their respective manors and fees in the said isles. And if anything, that sounds like a manorial court rather than a royal court. But that's,
Sorry, where was that? The 7, 8?
that was 6
The
lines
bottom
up.
of 787. To the
Oh,
bottom of
right at the
787.
bottom, is it?
Yeah.
Yeah, I see, yeah, I see it, yes.
It was also said yesterday that there was no evidence that a divorce couldn't be heard in Sark. I think that was said. Dawes deals with this, but the bundle reference, says page 2347, is incomplete, and you actually need to see the previous page, which has been omitted from the bundle. I brought those with me. I'm sorry to hand up yet more stuff. Thank you. So I'm told that, in fact, that point wasn't made yesterday, and that's accepted. If it is, that's fine. But you'll see on page 92, at the bottom, it deals with matrimonial causes division of the Royal Court of Guernsey. And then on the top of page 93, which is in the bundle, it says it follows that the Royal Court has a bailiwick-wide and exclusive jurisdiction in respect of divorce and most matters under 1939 law. Footnote 32, for what it's worth, says, note, however, that the Court of Alderney has jurisdiction to make certain orders for maintenance under the separation, maintenance and affiliation proceedings, Alderney Law 1964. That's the 3rd tab in the small clip I handed up this morning. On jurisdiction, the final point I'd make simply is that the 1931 ordinance obviously gives jurisdiction en meuble et immeuble, and I say simply that that must have a meaning. The 2008 Act, which is at page 940 of the bundle, does say there's an unlimited jurisdiction in respect of value, but it notably doesn't say that in respect of subject matter. It says instead, as you will all recall, that the Sark Court shall have the jurisdiction it had before that Act, together with any assigned to it by this law or by any other enactment. And we say simply that that's not the language of a court of unlimited jurisdiction from which things may be taken away. It's the language of a court which is given jurisdiction by way of statute and may be given additional jurisdictions. Turning to my Lord Wilson's question yesterday, when did the posited rights become part of customary law? And very kindly, though I've on occasion also been the recipient of your kindness, so I shouldn't complain, but kindly then said, perhaps that's an unfair question. But we said, no, it's not an unfair question, it's a critical question. When one is identifying a piece of customary law, it has to be proved. And you have to know the point at which it was first proved, when it came into being. Before that date, it wasn't customary law, and then it became customary law, and the courts recognised it. And then, as per the authority I handed up yesterday, after a certain point, the courts take judicial notice of it, and it no longer needs to be proved. So we say that's a very good question. And we say there is simply no reliable basis for saying that it has at any point come into existence. We say that 1868 loi relative à l'entretien des enfants illégitimes, the first thing that the Court of Appeal relied on, is of doubtful relevance. We say the only other source, Guillen de Carteret, from 1831, we say as we said yesterday, that that's scarcely a family law case. And then, turning to my learning friend's submissions, of course, as well as the 1984 law, which I dealt with at the beginning of my reply, and which I say doesn't do what she says, if anything, the contrary, and indicates there's no customary law right, she relied on a single case from the Seneschal, William and Martin. And that's at page, tab 72, I apologise, of the sixth volume of your authorities bundle. Get the page reference. I am nearly at the end.
I think it's tab 76 if it's William you're referring to.
I'm grateful. And that's at page 10 of the supplemental MS numbers. And we say simply, at page 11, you'll see the plaintiff and the defendant represented themselves, no legal assistance, jurisdiction wasn't discussed, customary law wasn't discussed, and in any event, a single case of the Seneschal in 2007 is insufficient evidence of the existence of this customary right. It is extremely threadbare, and this obviously plays into my quality of law, rule of law arguments.
What about, there were a couple of others, weren't there? What's wrong with Maunder and Bonifin?
So reflecting the distinction that appears to have been drawn in the 1984 Act, those were between married couples, those were judicial separations.
Ah, yes, I see.
But yes, I see.
And finally, because I see that my 30 minutes is nearly up.
I think you have 3 more minutes.
3 more minutes.
3 more minutes.
Thank you very much. If you're being asked to develop the right, it's obviously necessary to state what the proper scope of the customary law right is. And it wouldn't be enough simply to say, oh, well, in this case, we think that it would be a good idea. I don't want to pay you any disservice by saying that you might say that. But it's a substantive source of law, a customary right, and it needs to be properly defined. You have my submissions on Morton and Paint and what would be wholly inappropriate in this case in any event. 2008, legislative process begins, 2016, it ends, we're bang in the middle of the legislature being seized of this issue. And my final point is just in respect of Article 8. If I could take you to tab 41 of the third authorities bundle, I will give you a page number as soon as I can. So tab 41, and then it's the judgment of my Lady Hale at paragraph 77, which is 1774. And 1, 2, 3, 4, 5, 6, 7 lines down, she says, the state has a positive obligation under Article 8 of the European Convention to take steps which permit the child's integration in his own family. See Marx in Belgium. The child can scarcely benefit from family life if there is not enough to live on. But I accept that it is a considerable feat of interpretation to spell the right to receive regular, reasonable maintenance out of the right to respect for family life in Article 8. In my submission, that is exactly what this court is being asked to do today. And so for those reasons, I would say Article 8 also doesn't support the development of the rights contended for. That is my reply. Those are my submissions. And unless I can be of any further assistance, then I'll sit down.
I gather not. Thank you very much indeed, Miss Wakefield. You have, of course, introduced various new items to which, theoretically, Ms Gallagher has a right of reply. But I don't see her being anxious to exercise that right. Very well.
I wonder if the question of the Ogier edition has been clarified.
Yes, we were going to update you. It appears that over Christmas, because the authorities were prepared over Christmas at short notice, and there were multiple attempts to access documents over Christmas, it seems that there's been a confusion with the references. So some of the references given are to the second edition, some to the first edition, and I'm afraid the pages, when they were copied, are not all from the second edition. Yes. So I've spoken to my learned friend this morning, and we can, if it would be of assistance, send an email. It affects references for both of our cases. We can send an email with the correct references, but we're content to rely on the second edition. We don't want to put you, Lord Hodge, to the effort of having to give the references to your colleagues, we'd be quite happy to do that by agreement between council, if that would help. And there were two other outstanding matters which we're also going to liaise about, and they were the answer to my Lady Black's question in relation to payments. We're going to see if we can reach agreement, and we're very conscious of the reference that was made to the need for there to be agreed facts, and we hope that we can do that and answer what is a simple question. We think there's a simple answer. And also similarly, there's an issue about why this matter has taken so long to get resolved substantively, and again, we hope we can do that by agreement and update the court.
Well, it's not so much why as simply the chronology of events and where we now are.
We hope that we can do that by agreement and update the court.
That
And if
should
not,
be
we'll
possible.
inform you as...
Should be a matter of public record.
Yes.
Yes. Thank you. Thank you both very much indeed. Thank you for the economy, but comprehensiveness of your submissions in this extremely interesting case. We must now go away and put wet towels around our heads to try and work out what the answers are. Thank you.
Thank you.
Court is now adjourned.